Hi, good morning, everyone. I'm Sarah Crum, Managing Partner at SKC & Co. CPAs, and I'm here this morning with Lisa Salcido from Balance Point, a full-service human capital management provider. Lisa is the director of BPHR, Balance Point's HR consulting service that advises clients in all areas of human resources. We're so happy that you could all join us today. We're going to be identifying some specific details of the two new employment regulations recently passed here in New Jersey by Governor Murphy, the New Jersey Paid Sick Leave Act and the New Jersey Pay Equity Law. I know we've heard many concerns about these laws and how they're going to affect our clients' businesses, so hopefully we can shed some light on this for you today and demonstrate some possible solutions to implement in your companies. Let's start with an overview of the New Jersey Paid Sick Leave Act.
Thanks, Sarah. I'll start with a little background information on why this law was passed. Providing employees with paid sick time is a trend that's sweeping the country. New Jersey adds to the growing list of states that are enacting sick leave laws. Before it was passed on a statewide level, there were 13 different cities in New Jersey with their own ordinances requiring paid sick leave. This was a very complicated situation for employers operating throughout the state because each ordinance had separate rules. Employers with offices across the state were struggling to keep up with the regulations by location and managing their employees that traveled and worked in the different cities that mandated paid sick leave. Employers complained and pushed for one set of rules, leading to this statewide legislation to be passed, preempting those 13 ordinances. Governor Murphy signed the New Jersey Paid Sick Leave Act in May, and it becomes effective October 29, 2018. It applies to almost all New Jersey employers, and nearly all New Jersey employees are covered. The basics are pretty straightforward. Employers must provide 40 hours of paid sick leave to all New Jersey workers.
Lisa, I have to interrupt you and start with one of the most pressing questions that we've probably heard from most of our clients about this particular law. Many of our clients already provide paid sick leave to their employees as part of maybe a bundled PTO policy. And what we're really hearing from them is, will they have to change their PTO policy to include a separate sick policy, even if they already provide 5 or more total paid days?
The answer is, it depends. Employers can still provide a PTO bank made up of vacation, personal, sick days. However, there are several nuances in the Paid Sick Leave Act that may require adjustments to their current policy. The rate of accrual, reason for usage, payout, and carryover terms must match the paid sick leave law's language. As I get into the specifics, I will point out the distinctions that may require them to change their current policy.
That's terrific. I know that we're also working on making some changes internally in our firm regarding these laws. So we look forward to hearing some of those specifics as we continue this morning. You mentioned that this law applies to almost all New Jersey employers and employees. What are the possible exceptions that are out there?
Right. It applies to any employer that has workers in New Jersey. Regardless of how many employees you have, if you employ any workers in the state of New Jersey, you must provide them with 40 hours of paid sick leave annually. There are some exceptions, but they are very specific regarding public employers already subject to other paid sick leave laws, construction union workers, and per diem healthcare workers. Outside of those groups, all other private and public employers and employees are covered.
Wow, that sounds like still a lot of employers and employees are impacted by this. Do the 40 hours of paid time off need to be provided all at once?
Employers must provide 40 hours of paid sick leave to New Jersey workers. You do not have to provide all that time off at once. It can be on an accrual basis, where employees accrue 1 hour of paid sick time for every 30 hours that they work. Or the full 40 hours can be given to them upfront, known as front-loading the sick leave time. You can set increments for taking the time off, such as sick time may only be taken in increments of 4 or 8 hours. However, the increment set cannot be more hours than the number of hours in an employee's shift. So if you have an employee that works only 6 hours, your policy can't set an increment of 8 hours. Whether you go with the accrual method, 1 hour for every 30 hours worked, or the annual method, front-loading the 40 hours, you must first establish a benefit year. The employer sets the benefit year, which can be the calendar year, anniversary year, your fiscal year, basically any 12-month period that you choose. Once you choose your benefit year, you must inform your employees which 12-month period it will be. I recommend that you choose your benefit year carefully because once you provide notice to your employees, it will be difficult to change. To change your benefit year, you must notify the New Jersey Department of Labor in writing and follow a process to notify your employees.
So Lisa, when do the employees actually begin accruing the time?
So the act becomes effective October 29th, and your current employees will begin accruing as of that date. They may be able to use the time as they accrue it, although there are new proposed regulations that say they would have to wait 120 days, so February 26, 2019, until they can use it. I'll keep an eye on that proposed wording to see where it goes. For new hires, starting after October 29th, they will begin to accrue the time off as they start working, but they cannot begin to use it until 120 days after their date of hire. And this helps with temporary and seasonal employees and interns. One important point made throughout the law is that the paid sick time is truly capped at 40 hours. Employees cannot use more than 40 hours in a benefit year, and employees can't accrue more than 40 hours in a benefit year. One of the more confusing parts of the law is the carryover language. Although the law says the time can be carried over, the paid time off cannot accumulate past 40 hours. Remember, employees cannot use more than 40 hours in a benefit year. So if an employee does not use any sick time in an entire benefit year, technically, they can carry over that 40 hours. But then they are not front-loaded, nor do they accrue another 40 hours in that year because they are capped at 40 hours. If an employee uses 20 hours of sick time in a benefit year, they could, in theory, carry over the remaining 20 hours of sick time, but that does not mean that they have 60 hours to use in the next benefit year. They are still capped at 40 hours. The only way the carryover makes sense is if an employer chooses the accrual method, and let's say the calendar year as the benefit year. And as an example, over year one, an employee accrues their 40 hours, but only takes one sick day all year, so 8 hours. They can then carry over 32 hours, and those 32 hours are now available to them at the beginning of the calendar year instead of waiting to accrue time. But then in that year, they would only accrue the remaining 8 hours to keep within the 40-hour max. Remember, employees are never permitted to use more than 40 hours in a benefit year. And be careful if your current policy has a use it or lose it language, because the poorly worded carryover language in the law would conflict with some of the instances of use it or lose it.
Right. I know internally we had to change our PTO policy because of the carryover language as well. So that's something that business owners really need to pay attention to. Lisa, what about paying out the time instead of the option of carrying it over?
Sure. So I'm going to give answers for both the annual front-loading method and the accrual method. If you use the annual front-loading method, at the end of the benefit year, the employer also has the option to pay out the unused time instead of carrying it over. This is completely optional for the employer. If cost is at all an issue for you, I do not recommend paying out unused time in lieu of carrying it over, because after the payout, you are still providing another 40 hours of paid sick time in the next benefit year. If you decide to use the accrual method, at the end of the benefit year, the employer again has the option to pay out the unused time instead of carrying it over, but only if the employee agrees. You can then offer to pay out all of the unused time or 50% of the unused time. For reasons that are not clear, those are the only options: pay it all out or pay out half. Again, this is only if the employee agrees, and you have to give them 10 calendar days to decide. If they don't agree, then the time will be carried over. If you do opt to pay out any unused time, you must pay it out in the last month of the benefit year, and it must be paid out at their normal hourly rate.
I love it when laws have things that are unclear in them. That hardly ever happens, and especially in New Jersey. How about the unused paid time? Does that need to be paid out upon separation of the employee and the employer's relationship?
So there's nothing in the law requiring employers to pay out unused hours after separation. However, if you already have a policy or practice where you typically pay out unused time, then you do need to follow or change that policy. So this is one of those specifics where we can't definitively say that your current policy is compliant without reviewing it. Or if you don't have a policy in writing, then we need to understand your typical practices when employees resign or are terminated. I just want to mention that managing all of this using a time tracking solution is essential. This law requires you to track the accruals, track the usage, keep it capped at 40 hours, and track optional carryover and payout situations. Balance Point has time management solutions that can keep you in compliance and relieve the tracking burden of this law.
Yeah, the record keeping alone on this is really intense, and we have less than a little bit over a month actually to really implement this and get this going. So there's a lot to think about. What are some of the reasons that employees, based on the definition in the law, can take sick time?
Okay, so this is another instance where your current policy, even if it offers 40 or more hours of paid sick time, may not meet the law's requirements. The reasons it allows employees to use the sick time off, because the definition of sick is pretty expansive in the law. Some of the reasons employees can use this paid time that are not traditionally considered sick time are recovery from a mental illness, preventative care like getting a flu shot, caring for or preventative care for a family member, if the employee's child's school or daycare was closed due to a public health emergency, or if the employee's child's school needs to meet with a parent regarding their child's health, if the employee or a family member are a victim of domestic abuse or sexual violence. And just a side note here, New Jersey has another law called the New Jersey SAFE Act, which provides employees that are victims of domestic abuse 20 days of unpaid leave to obtain safer conditions following domestic violence. I'm not going to get into this one today, but just keep it in mind since both of these laws provide unpaid and now paid leave in these situations that, again, may not be traditionally thought of as sick time. The law further defines family member as child, grandchild, sibling, spouse, domestic partner, civil union partner, parent, grandparent, all the standard ones. But then it gets much broader, like grandparents' domestic partner or your spouse's sibling, and even any other individual whose close association with the employee is the equivalent of a family member. So if your employee considers their roommate's uncle's brother to be their cousin Vinny, and cousin Vinny needs your employee to take him to a court hearing related to a domestic violence case, as unrelated to a sick day as that sounds, it's probably covered under this law. So again, if your current sick leave policy mentions any reasons why employees can take sick time, you'll need to revise it to cover cousin Vinny and others and allow your employees to use the time for the purposes time off is available under the law. Also, if your current policy has some restrictions, like employees must give advance notice before taking time off or finding someone to cover their shift, that's not going to work if your employee wakes up sick and can only provide short notice. This is particularly related to those of you with a PTO policy where you provide a bank of days that cover vacation, sick, and personal. If the PTO policy mentions a notice requirement to request time off, then you'll have to do away with that or move to a separate sick policy that has different notice requirements than vacation and personal days. Now, you can have a provision that says if the leave is foreseeable, employees are required to provide 7 days notice. So if they have an appointment for a physical scheduled for next month, you can require them to take 7 days, to give 7 days notice. But again, if notice is not practical, employees can take the time off as they need it. So let's talk about doctor's notes. They're optional. You can require a doctor's note if the employee takes 3 consecutive days of leave, or if you'd like to require a doctor's note for foreseeable leave. However, there's nothing in the law regarding challenging questionable doctor notes. So if you require a doctor's note, but you don't feel the employee provided a real doctor's note, the law does not address any actions the employer can take. Next, record keeping. This law has very important record keeping provisions. Employers must keep records of all time related to the law for 5 years. So that means tracking time worked, sick leave accrued, sick leave used, paid out, or carried over. This is important because if a complaint is filed where an employee claims that an employer was in violation of this law and the employer does not have clear and convincing documentation, the law presumes the employer to be guilty. Balance Point's human capital management software can store documentation and track hours so you are always able to defend your organization against any complaints. Let's talk about retaliation. Another important provision in the Paid Sick Leave Act is the provision regarding retaliation. Employers cannot discipline or terminate employees for using their paid sick leave. There's very critical language in the law that says an employer will be presumed in violation of the law if the employer takes an adverse action against an employee, adverse actions such as demotes them, terminates them, docks their pay, within 90 days of an employee filing a formal complaint under this law, talking to an attorney, talking to a peer about the law, or just taking sick leave time. So let's say you have an employee making a lot of noise around the office regarding this law and saying the employer is in violation of the law, and you take an adverse action against that employee within 90 days, it will be presumed that the employer is in violation of the law. And by the way, violations of the law could cost you back pay, attorney fees, fines, and administrative penalties. And violations could be based on discrimination, retaliation, or the record-keeping requirements. Also, violations could be uncovered from a wage and hour audit, a complaint, which could be made anonymously, or if an employee sues. The law also takes willful violations more seriously, and the new proposed regulations mention that a willful violation will be equal to a disorderly person's offense. So that's interesting. The law has quite a few gray areas that I want to mention. First, employees who cross state lines for work. So if you have a salesperson based out of New Jersey but frequently sees clients in New York, some interpretation of the law says that the employee only accrues 1 hour of paid sick time for every 30 hours worked in the state of New Jersey, and his time working in New York would not count towards the accrual. That's one interpretation, but it's not really clear at this time. Another gray area is part-time employees that may not work enough hours to accrue the full 40 hours of paid sick leave. Right now, the law is unclear if you must front-load them the full 40 hours or if they only earn based on the hours that they work. If all employees must have the ability to earn up to a maximum of 40 hours, it would seem that you'll need to increase the hours that they work or just front-load them the time. But the law doesn't specifically address this yet. Either way, be careful with tracking and record-keeping for those traveling, part-time, and fluctuating hour employees. These gray areas will need to be further defined by the new regulations or by court decisions in the future.
Thanks, Lisa. That's a lot of information, and we do know that more is going to come out as this law comes into practice at the end of October and court decisions come and more clarification on these regulations. But for now, what is it that our clients, business owners, employers in the state of New Jersey need to do to comply with this law?
Okay, so first, decide what your benefit year will be. That's any 12-month period that employees will receive and be able to use paid sick time. Then choose the accrual method, where employees accrue 1 hour for 30 hours worked, or decide that you will front load the time where you provide the full 40 hours up front. Then create your full sick leave policy and update your handbook to communicate your policy to your employees. You want to make sure you lay out the procedure for taking time off, where employees will be able to check their balances and address how you will handle part-time employees. If you want to keep a PTO policy that is more generous than the law, so a bank of days that gives you more than 40 paid hours, you have to make sure the permissible reasons for using the paid sick leave is allowed in your PTO policy, as well as the notice requirements. If your current PTO policy does not allow for carryover, and remember the carryover language is confusing, then it's not going to be compliant. It is tricky to use a PTO policy and be compliant with the law. The easier approach is splitting up your paid time off into separate vacation, personal, and sick leave policies. Next, use a time tracking tool to comply with the record-keeping requirements. Remember, you must keep records of all time related to the law for 5 years. That could be hours worked and accrued, time advanced and used, paid time out, or carried over. Finally, train your managers and supervisors regarding the law, your procedure for requesting time off, the reasons that employees can use to take the time off, and the retaliation provisions. Balance Point's HR consulting service can assist you with every step from writing policy, creating handbooks, and training your staff.
Thank you, Lisa. That, again, is so much to do in the next 40 or so days, and please use Lisa, use your contacts at SKC as resources. We want to be able to support you through this new law as we navigate it side by side with you. So let's pour that second cup of coffee and let's switch gears and take a look at the New Jersey pay equity law.
Okay, so New Jersey Governor Phil Murphy recently signed the Diane B. Allen Equal Pay Act. This act amends the current New Jersey law against discrimination and has been expanded to provide significant employee protections which are more comprehensive than the Federal Equal Pay Act and pay equity laws in other states. The law states that it is illegal for an employer to pay any of its employees who are members of a protected class at a rate of compensation, including benefits, which is less than the rate paid by the employer to employees who are not members of the protected class for substantially similar work. That's a mouthful, but we're going to break that down for you. So this law already went into effect on July 1st with very little warning, especially considering how expansive the law is and how difficult it will be for New Jersey employers to comply. The law has been widely criticized for being vague with very little guidance for employers.
Definitely, and I'd like to emphasize that you use the term protected class, and really that's what this law applies. It's a broad range of protected classes. It's not a specific gender equity bill. So let's get into some more detail of what the purpose of this new law truly is.
The main purpose is to strengthen the protections against employment discrimination and to promote equal pay by bringing consistency and transparency to pay practices. So let's look at some of the ways that the new law strengthens protections for employees. First, all New Jersey employers are covered. Public employers, private employers, small businesses with 2 employees, large businesses with 2,000 employees, you are all covered under this law. Next, we've all heard of equal pay for equal work. That concept has been around for a while. Well, get ready to replace equal work with the ambiguous substantially similar work.
Sounds like potentially another gray area. Lisa, what's considered substantially similar work under this law?
Great question. Unfortunately, the New Jersey Pay Equity Act does not define it. So far, all we know is that it's a vague mix of skill, effort, and responsibility. More on this later. In addition to all employers being covered, this law expands beyond gender, as you mentioned, Sarah, so to cover all protected classes. You may already be familiar with some protected classes. Take a look at this slide. These are all of your employees that are protected under this law. This broad list of protected classes is basically your entire workforce. On average, the typical employee is covered under 3 protected classes. Now, you may know the age and marital status of your employees, but would you know their genetic information or if they had a mental disability? You likely would not, and certainly you don't want to go around asking them. So your best practice would be to assume all of your employees are protected from discrimination by the law. Employers do not need to have known the employee's protected classification to be in violation of the law. Lack of knowledge or intent is not a defense. We can't stress enough that this law is aggressive. You've seen the headlines, comprehensive, toughest in the nation, and it's true. The key amendments of the New Jersey pay equity law are comprehensive in its protections for employees and its penalties for employers. For example, going beyond gender and covering all of the protected classes is broader than any other state law. And that vague and subjective term, substantially similar work, while other state laws provide an employer-friendly standard when it comes to comparing job responsibilities, whereas New Jersey has created a real challenge when it comes to determining which positions are substantially similar to other roles in your organization. But most aggressive of all are the penalties in this law. Let's take a look. If your employee makes a claim that they have not been paid equally for doing substantially similar work in comparison to another employee, it will be up to you to prove that the difference in pay was not discriminatory. Now, of course, the pay disparity was likely innocent, as in you didn't pay one employee a higher amount because your other employee is in a protected class. But because lack of knowledge or intent is not a defense, you would have to be able to prove that the pay difference was based on legitimate factors, such as training, education, experience. Your proof would have to be documented. You'd have to be able to hold it up in court. And if not, you could be looking at paying the difference in pay for up to 6 years in back pay. That means you could be sued 2, 4, 6 years from now and owe back pay from July 1st, 2018. Again, comparatively, this is very aggressive. Other pay equity laws set the back pay penalty at only 2 years. And just to understand that statute of limitations further, for each paycheck that you issue that contains an unequal pay rate, you are charged with a separate act of discrimination. Each paycheck is a new violation, restarting the statute of limitations. And if you end up in court and the case goes to a jury trial and the employer is found guilty, the judge could award the claimant monetary damages on top of the back pay up to 3 times the amount they were denied in compensation. Let's look at a sample calculation to get the full picture. Let's say you have employee 1 that fits into a protected class and is earning $50,000 per year. Employee 1 becomes aware that the company is paying $60,000 to employee 2, who is doing substantially similar work as employee 1. Employee 1 and their attorney sit tight for years, building their case, while you issue paycheck after paycheck that contains the unequal amount between the 2 employees. Employee 1 and their attorney file a discrimination claim. Now, in all likelihood, you weren't paying employee 1 $10,000 less than employee 2 because of the protected class. When they were hired, you offered $50,000 and employee 1 accepted it, and you thought you were getting a bargain. Not so fast. If you have no documented, concrete proof as to why you paid employee 2 $10,000 more, you could owe employee 1 6 years of back pay plus 3 times that amount in damages, $240,000, and that's without your attorney fees. Not much of a bargain anymore. These accumulating damages are the reason that employment lawyers are salivating over the opportunity to capitalize on this law and are incentivized to wait and build discrimination claims over time. In addition to the monetary penalties, employers could be required to reinstate an employee to a position or give a promotion or restore different types of benefits or reimburse the plaintiff for their attorney fees.
As always, it's a great day to be an employer in the state of New Jersey. So let's actually dive in a little bit deeper and review some of the risks to the employers.
Okay, so first, the burden of proof will be on the employer to prove that they have not violated the law. In the example from the last slide, it's important to understand that in order to bring a claim against you, employee 1 does not have to prove you discriminated against them. You have to prove that you have not paid them an unequal amount because of discrimination. The law requires employers to justify differences in salary by demonstrating the pay disparity was not based on discriminatory factors. So if you have not documented every hiring process, have copies of every offer letter, have documented reasons for any pay increases, along with performance review metrics, you're not going to be in a position to defend the claim successfully. Next, pay equity claims against employers are on the rise. Now, if you believe you won't have a pay equity claim brought against your company, be aware that the Equal Employment Opportunity Commission has reported that the number of equal pay violations have risen substantially across the country, in part due to media coverage that feeds employees with narratives about gender or minority pay gaps. Those narratives are why we are seeing these new laws pop up across the country. And of course, New Jersey's law is particularly one-sided. So if you haven't been paying attention, it's not on the side of the employer. Next, the New Jersey law doesn't specifically address geographic or regional issues. It's written to be statewide. So if you have a location in northern New Jersey and a location in southern New Jersey, it would be reasonable to believe that you can justify salary differences by the cost of living in the different areas. Currently, the law doesn't clarify if that is allowed. We're left to interpret this on our own. If this were to be a legitimate factor for a pay difference, the employer would need to be able to clearly demonstrate the business necessity, that it's applied reasonably, that it's not based on a protected trait, nor does it perpetuate a compensation disparity. And be careful with the business necessity defense, because the law includes a caveat that employers must consider alternatives before making a decision that results in a pay disparity. Another risk to employers is the anti-retaliation provision, which expands employee protections in regards to discussing wages and benefits. Now, hopefully you are already aware that you cannot prohibit your employees from discussing their salary, benefits, or working conditions. The National Labor Relations Act has long provided employees the right to discuss salary, benefits, and working conditions with each other, and those discussions can be in or out of the office, through email, through social media. So that's already been the law. What we have now is an expansion of those rights and new protections from being retaliated against for disclosing information concerning compensation and benefits. This goes back to the purpose of this new law, which again is to promote equal pay by bringing transparency to pay practices. So if you've been wondering, well, how can they sue me if they don't know how much I am paying my other employees? Be aware that your employees can and will share what was once thought of as confidential salary information. In fact, an employee can post their offer letter on social media without any fear of retaliation based on the expanded anti-retaliation provision, and there's nothing you can do about that exposure. The law also adds that employees cannot waive their right to discuss wage and benefits. So if you, the employer, have a policy in your handbook, or if you have a confidentiality or non-disclosure agreement that you intended to prevent your employees from discussing their wage and benefits, you'll need to review and revise those documents immediately. Finally, the effects of this new law will not be immediate. Honestly, you're not going to hear about New Jersey pay equity cases in the weeks or months to come. And the reason lies in the penalties. Remember 6 years of back pay and those accumulating damages, and those evil employment attorneys convincing their plaintiff clients to be patient and let each paycheck count as a separate act of discrimination? This type of law percolates in the background, causing a false sense of security. Remember, each discriminatory paycheck resets that statute of limitations. If we don't hear about the effects, the law can be easily forgotten about, which is very risky. So if you don't start protecting your organization now, you won't be prepared in the future when you're hit with a claim.
So what can business owners and employers in the state, what actions can they do now to protect themselves?
So first, you're going to need the data and details on your workforce. Data such as job title, job description, compensation, performance reviews, resumes, offer letters. The list goes on and on. For now, let's take a look at job title and job description. To determine substantially similar work, job title alone is not sufficient. you'll need to group your employees by their job responsibilities. To do that, take a detailed look at what they do as described in their job description. Let's take a look at an example. Let's say you have an executive assistant to your CEO and a financial assistant to your CFO. Does an executive assistant and a financial assistant perform substantially similar work? Well, they're both assistants to the C-suite. That's similar, but we need to look closer at their responsibilities. The executive assistant assists the CEO in probably a high-level capacity with a variety of tasks. And the financial assistant, although also assisting at a high level, the tasks are likely more related to finance. Now, maybe not exactly similar, or are they? They are both assistants at substantially similar levels in the organization, and their tasks, although one is more finance-focused and the other is usually not financial, well, wait, sometimes an executive assistant does support the CEO related to financial matters, but not all the time. Do you see how challenging interpreting substantially similar work can be?
So are these two assistants considered doing substantially similar work?
Maybe. We just don't have enough information to determine that.
So what can our clients do?
Well, you'd have to dive deeper into each responsibility listed in the job description and analyze it. But remember, the New Jersey pay equity law does not provide any guidance on what needs to be analyzed. I took a look at the Federal Equal Pay Act, which uses substantially equal as opposed to substantially similar, and it measures by skill, effort, responsibility, and working conditions. So that gives us a starting point. Well-written, updated job descriptions for every employee measuring at least skill, effort, responsibility, and working conditions will need to become part of your process to ensure compliance with this law. If you don't have any job descriptions, you need to start creating them. If you have some job descriptions, but not all, or they have not been updated recently, congratulations, you have a new project to work on. Remember, to mitigate risk, you're going to need accurate and defensible data.
Document, document, document. Lots of paper is going to accumulate from this law, I think. So let's say that our two assistants from the earlier example do have similar job descriptions that have been analyzed and are identified as substantially similar. So do you then have to pay both assistants equally with no exceptions? What if in this situation the financial assistant has an MBA and 10 more years of experience and really exceptional performance review results?
So the good news is pay disparities can exist for legitimate factors such as seniority, merit, training, education, experience, or quantity or quality of production. So an MBA, decade more of experience, outstanding performance, those are all good arguments for a merit increase. However, the factors that a pay disparity are based on cannot perpetuate a differential in compensation based on the protected class. Meaning if you have a class of employees that have a higher level of education than another class of employees, and you consider that a factor, it may have the impact of disproportionately affecting minorities. Also, if the financial assistant has a degree in music, that would not be job related in respect to her position. It would have to relate to the job to meet an educational requirement for a legitimate pay disparity factor. So before you get comfortable with a certain explanation for a difference in pay, be sure they actually hold weight and you cannot be perceived to be based on discriminatory factors and that you have thoroughly documented and tracked your proof.
Lisa, there just seems like so much to do. Is there anything that we could give as advice that our clients should avoid doing or things that maybe they shouldn't be doing in response to this law?
Sure. So if you're thinking a simple solution would be to just lower salaries to match others in the same pay group, don't do that. The law specifically states employers may not reduce the salaries of higher paid workers to comply with the law. Next, don't ignore this law. I know it's very broad and poses a lot of challenges, and you may feel inclined to just roll the dice and hope an EEOC complaint or lawsuit never comes in the mail. Instead, take action now. We don't know the future of this law, its regulations, future amendments, or how the cases will play out in court. You don't want your company to be the case study. Be proactive now so you don't have to pay later. If you don't conduct a pay analysis, you won't know if your company is at risk. Finally, don't tackle this alone, and this is really important. If you choose to conduct your own internal pay audit and it's not done correctly, or it's started and not completed, or it uncovers pay disparities that you ignore, a discrimination claim brought against your company could now be considered intentional, which could result in punitive damages on top of the penalties we've already discussed. Use an outside resource like Balance Point or SKC to conduct your pay analysis to protect your data, your results, and your pay decisions.
We can't emphasize that enough. Reach out to your contacts at SKC, reach out to myself or Lisa. We'll put up our contact information shortly. I mean, this has been an intense amount of information between both of these two acts. If you've made it this far with us, you probably have more questions than when you first started with us at 10 o'clock. Please know that we're all here to help you through this process. You'll see my contact information and Lisa's up on the screen. If you have a different contact at SKC, please reach out to someone on your team. Use us as a resource. This is not something that you necessarily want to be trying to navigate on your own. There's definitely going to be more things that come up as these cases are litigated and new regulations and clarifications come out and are developed through the courts. So we're here to keep you stay as current on these changes and help you navigate the challenging laws to protect your business and keep growing and moving forward. So Lisa, thank you so much for joining us to provide this information. On behalf of SKC and Balance Point, thank you so much for joining us and have a terrific day.